I'm Théodore Christakis. I'm professor at the University Grenoble Alpes and director of research for Europe with the Cross-Border Data Forum, created a few years ago by Professor Peter Swire, here present, where we're doing a lot of work trying to promote thinking on these issues concerning government access to data and international data transfers also more generally. And today, as a matter of fact, we thought with my co-panelists that it could be great to focus a little bit on this concept of essential equivalence as a test for transfers, and to try to find out that this is very topical also in relation with what is going on with discussions around the new draft adequacy decision to be adopted soon. And the idea is to try to discuss a little bit this concept under the prism of different legal cultures, legal pluralism, how flexible this concept could be in order to accommodate for different legal systems and different solutions, probably not exactly the ones as we have in Europe. I will introduce the topic immediately, but I would just like, first of all, to introduce the great speakers that we have today, and I have already talked about Peter, who is a professor, one of the greatest experts, if not the greatest, in the United States on data protection. And if President Clinton and President Obama asked him to be their advisor on these issues, they knew something, and who is professor at Georgia Tech. And Anna Buchta, you all know here, who is a precious member of the EDPS and has been working on all these issues concerning data protections for years. And last but not least, Nora Loideain. It's good that you have a French pronounceable name. It's very easy for me to pronounce, or Loideain in Irish, but I will not try this, who is one of the greatest academics working on surveillance issues for years, and you have all read her great publications and contributions on these issues. So I will give them immediately the floor for this concept, but I would just like to say a very few words about this. The point of departure, of course, is the GDPR in Europe, which clearly states that the level of protection of natural persons assured in the Union by this regulation should not be undermined when there are international data transfers. So the GDPR is in favor of international data transfers, very much in favor. It's in the DNA of the GDPR, but data should be transferred with protections, which means that immediately afterwards, in Article 45, we have this concept according to which the country towards which the data are transferred must ensure an adequate level of protection, says Article 45, which creates immediately a lot of debates about what the term adequate means. In English, I think that the term adequate has a meaning of enough or satisfactory for a particular purpose, which could be understood as a level of protection that is just satisfactory or sufficient. In French, though, the same word refers to something which corresponds perfectly to its purpose. It's appropriate, suitable. And the GDPR circumvents these interpretative issues by referring to the term used by the Court of Justice already in 2015, and we find it in Recital 104. The GDPR says that the third country should offer guarantees ensuring an adequate level of protection essentially equivalent to that ensured within the Union. So the GDPR did copy-paste Schrems I. And as a matter of fact, if we refer back to the court already in Schrems I, the court said, I quote, that a third country cannot be required to ensure a level of protection identical to that guaranteed in the EU legal order, but a level of protection that is essentially equivalent. And the court continued by saying this protection may differ, but those means of protection must nevertheless prove in practice effective in order to ensure protection essentially equivalent to that guaranteed by the European Union. So the Commission took this idea and they tried to interpret it. If you see, for instance, the UK adequacy decision, you will see that the Commission says that the test lies in whether, through the substance of data protection rights and their effective implementation, supervision, and enforcement, the foreign system as a whole delivers the required level of protection. And the EDPB wrote that the objective is not to mirror point by point the European legislation, but to establish the essential core requirements of that legislation. And then if you read, for instance, the EDPB's opinion on South Korea, which is very interesting, you will see once again that the EDPB says that the objective is not to mirror point by point, but to establish the essential and core requirements of the legislation. Adequacy can be achieved through a combination of rights of the data subjects and obligations. And this creates a lot of questions. The EDPB says it depends on the case, so we have plenty of questions. For instance, if the surveillance system in the other country does not meet some of the European requirements, but meets some others, is that enough, or we really need, to check all the boxes? How exactly are you going to interpret? And you understand that you have to have, if you want to have a system which is coherent, you must apply exactly the same standards for South Korea, for Japan, but also for the United States. You cannot say that for the United States you will have higher standards, for instance, than for South Korea or Japan or the UK, where they have there were some very, very important problems with the surveillance systems, but we see, for instance, that the EDPB adopted the flexible approach by saying that, yeah, but we have other good things, so as a whole, the core requirements of protections are reflected. And this meets what we introduced also in the program, which is the opinion of Advocate General in Schrems II already, who said that the law of the third state of destination may reflect its own scale of values, and the protections might diverge from that in the EU legal order, but the protection of personal data that prevails within the European Union, he said, meets a particularly high standard, and we cannot expect this from other countries. We have to preserve a certain flexibility to interpret the concept of flexibility in order to take the various legal and cultural traditions into account. So the Advocate General spoke about certain minimum safeguards and general requirements that need to be protected. And this idea has been taken by the former EDPS, Peter Hastings, who said that these provisions are based on a reasonable degree of pragmatism of European data protection law in order to allow interaction with other parts of the world, because if we really want to impose in an imperialistic way our standards as such, then we might not be able to do commerce and to have international data flows. And Professor Christopher Kuhner took also this idea, and he wrote, I'm almost done, Mr. Chair, I am the one, promoting the GDPR, wrote Professor Kuhner, in other regions with different legal and cultural traditions requires the EU to walk a fine line. The standard of protection should be high in order to make it a desirable model, but it must be set at a level that is possible for a third country to attain. And Christopher Doxey also built, I don't know if he's here on this idea, by saying that the adequacy is not absolutely equivalence. And he went on, and we developed this idea with Peter Zwaneken proper in our article on redress, by saying that if the content of some rights in the Charter of Fundamental Rights, such as Article 47 about redress, are is ensured, then the form should not be an obstacle. And it seems now that the EDPB adopt, in the recent opinion, the draft adequacy decision concerning the US, we found this idea for the first time that EU law is about substance, it's not about formalism. We're very happy because this was exactly the idea that we were developing in our articles long time ago with our proposals on redress. Let me just finish by saying that this discussion is not new. Of course, it's particularly relevant in relation with the US adequacy decision, but already with the UK adequacy decision, we saw a very strong, for instance, bras de fer between the Commission and the EDPB, and there were some documents which were leaked in Politico with the correspondence, and I will just quote what the Commission wrote to the EDPB, which initially adopted a very strict approach against the UK adequacy. I see the members of the EDPB who start reacting, but let me quote, this is public, it's Politico, it's not me. If adopted without being significantly rebalanced, the position of the EDPB on UK adequacy, these opinions will be welcomed by those who will use these critical opinions to show that our model is not credible as a global solution and that adequacy is basically mission impossible. And the European Commission added that an inflexible approach by the EU bodies risked sending a message to third-party countries that whatever you do in terms of convergence with EU data protection rules, it's never enough. Of course, we have seen that the EDPB concerning the use adequacy adopted a much more pragmatical approach, which was a very positive surprise, but still the LIBE committee in its resolution just continued, they were already very negative concerning UK adequacy. There's nothing new, it's exactly the same kind of attitude. And we see here why we need this debate. And after all this introduction, which I hope was a good aperitif for the great interventions that we will hear, I'm very glad to give immediately the floor to Peter Swire, who precisely will try to explain to us what we don't know, which is some divergence in legal systems and constitutional systems that probably we might need to take into consideration. Peter, you have the floor.
Thank you, Théodore, for those great remarks. Can you hear me in back? Is the mic on? Yeah? In back, somebody nod? Okay, thank you. So I'm going to talk about US constitutional law and how it fits in with redress in particular. And we start with the idea of rule of law in the European Union and the United States. And many non-EU lawyers, many American lawyers, have learned a great deal about EU fundamental rights law in the last bunch of years. And with the data privacy framework, I think it becomes newly relevant for European lawyers to consider the US constitutional constraints that we operate under to inform these issues. And there's three issues I'm going to do that on. The first is what the US law calls standing, which is when you can go into court. The second is independence, what counts as independence under US law. And the third concerns the president's unique role for foreign affairs and national security. So standing. So the legal challenges, Article 47 includes the requirement that there be an independent and impartial tribunal. And I'm having a difficulty with my aging eyes, so I'm gonna have to open my computer so I can read the font, and then I will advance it for you as well, and try to speak clearly enough if you can't read the font. So give me just 1 second. So there needs to be an independent and impartial tribunal. That's the charter. One proposed solution is let's have redress claims in US federal court with the Article 3 judges. But there's a constraint on getting to Article 3 judges, to federal courts. And the data privacy framework solution is, yes, have independent adjudication, but not in Article 3 courts. And I'll walk through how that works. Oh, I haven't done this with two hands for a while. It's a great little trick here. So, yeah.
Peter, why don't you change with Nora to be able to read over there?
Oh, if I can do that with the mic, that might work better. I'm sorry. Yeah.
Or you can just stand over there, or
yeah. so that now I can be a singer or something like that. But at least I can read it. So that's a real positive. Let's see.
It does? The micro
Okay.
works?
Okay. So here's Article 3 of the U.S. Constitution. The words in our Constitution say there can only be federal courts if there's a case or controversy, not just advisory opinion. And a required element to have a case or controversy is what the court calls injury in fact. The individual plaintiff has to be injured in some specific way. So 2 years ago in 2021, this is recent Supreme Court law, we had a startlingly narrow opinion about privacy standing. I don't support many of the decisions of the Supreme Court, but I'm describing what the US Supreme Court is. We're a rule of law, we have to deal with that. So in this Ramirez versus TransUnion case, there was a claim under a statute, the Fair Credit Reporting Act, and the statute gives you a right to sue if there's inaccuracies in your credit history. Here are the facts. Thousands of people in the credit history said they were on the terrorist watch list. Very bad mistake in the credit history. Supreme Court said some of the people could sue, the ones who had that information sent to third parties. But thousands of people could not sue as a matter of constitutional law because the credit agency had not given that information to anyone else. It was wrong in the database, but that wasn't enough to be an injury. And so there was no injury in fact, even though there was this terrible mistake in the person's credit history. So from this case from 2 years ago, we have a constitutional requirement of standing, and even when Congress writes a specific statute to create standing, that was not enough to protect privacy in this case. So there's been no proposal that I've seen that fixes the standing problem for redress. We've spent years, Théodore and I have spent years trying to figure out how to do this. There is a proposal by the American Civil Liberties Union. They say, here's a way to get an injury. Some individuals take action to avoid surveillance. They pay for special software. Then they've been injured, then they can sue. Okay, that's fine. But Article 47 requires the standing for every individual, even people who have no injury, who've never had any problem before. And so most people in the European Union haven't bought the special software. And so the ACLU does not meet a fundamental European requirement that everybody be able to have redress for the possible violations. So what happens in the framework is to create a new tribunal. I don't love the word court for the Data Protection Review Court, but create a new tribunal by actions of the President and the Attorney General, not by a statute. And then a redress claim is, voila, available to every individual from Europe. Okay, so that's achieving an essential requirement, as I understand it, for European law, that any individual be able to sue. Sorry, can't get to federal court. Next is a new statute required. And Théodore and I, with Ken Propp, wrote these long, many footnote articles trying to explain some of this. But the point here is that Article 47 of the Charter and Article 6 of the European Convention require the tribunal to be, quote, established by law. We've heard those words otherwise today. What's established by law? If there's a statute, yes, that's established by law. But also, can a tribunal be established by law without a statute passed by the legislature? And relying on Théodore to know international public law and European law, we concluded that yes, you can get to established by law without a statute. Common law decisions, regulations, other things count as established by law. And this is important because there's two apparent constitutional constraints on the role of a statute. And let me just say, these slides are now available online at peterswire.net. There will be an article saying this, I hope, by the end of the summer. So the first one of these is there's constitutional limits on how to create independence. Well, that's a problem because independence is super important under the European scheme. There's also US constitutional limits on Congress's power, you might say competence, Congress's power over national security and foreign affairs. And that's important because even international surveillance, Executive Order 12333, has to be protected according to the Court of Justice. So how do we handle this in the data privacy framework? Well, we create an independent tribunal, not in federal court, but by a Department of Justice regulation, a regulation issued as a matter of law. And then we create a binding effect of the tribunal with an executive order. The president has given a binding legal order to agencies. The agencies have to follow this. And so when the Department of Justice has these judges and the judges issue an opinion, the president has ordered the agencies to follow the opinion. That's required by law. That's established by law. Or at least the closest we can get. Now let's talk about these puzzling things. Here's a case that I dislike intensely, but it happens to be a Supreme Court case from 2 years ago. Okay, so there's a US versus Arthrex case. Congress passed a statute. They created independent judges to decide some patent disputes. But the patent office couldn't overrule the judges. No other official could overrule the judges. The judges had final say. Supreme Court said, sorry, that's unconstitutional. Cannot do that. There has to be a politically accountable official to look over these decisions by these patent judges. Oh no, so this is terrible. So the puzzle is, how can you create an independent tribunal when there's recourse to a politically accountable official, right? It's impossible, but law professors like to do things that solve paradoxes, and so here's the answers out of this. The answer is the officials, the President and the Attorney General, voluntarily give up some of their own power. It's not Congress seizing their power. So the President gives up some of his own power and creates a legal structure that the President then cannot change except with procedures. So voluntarily giving up your power means it's still within the control of the political official. So here we have the Attorney General issuing a regulation. Attorney General usually gets to decide things that happen from the Department of Justice, but he has a discretionary power, and he gives the Data Protection Review Court the final decision. The President did the same thing, and they can take back their power. Tomorrow, the Attorney General could repeal the regulation. You'd know about it. Europe could repeal adequacy, but there's still the possibility for the Attorney General to change the reg. There's power for the President to change the executive order, but that would be the end of adequacy, in my view. So as long as those things are there, you have adequacy, because they are binding by law. And there's Supreme Court precedent. I'll skip to the second case just in the interest of time. Supreme Court case called Accardi. The Attorney General wrote a regulation. The Attorney General said the immigration judges got to make the final decision. Then later on, he didn't like a decision on deportation. He said, no, they have to be deported. The Supreme Court said, no, they cannot be deported so long as the regulation is in effect, the immigration judges were the final decision. That's what the DPRC does. So long as the regulation is in effect, the judge's decision is the final decision. The Attorney General cannot overrule the decision. Tomorrow he or she could change the reg, but they can't overturn the decision. So the independence of the DPRC following this immigration case is specifically allowed because the Attorney General and the President use their discretion. A statute saying the same thing would be unconstitutional. Relatedly, the President has a special role in foreign affairs. You're familiar with competence of member states and the European Union. And this is important because the Schrems case, the second case, said foreign surveillance collection, Executive Order 12333. That foreign stuff has to be included in the US regime. There has to be redress even for Executive Order 12333. One proposed solution would be to have a new statute. Congress could say, oh, we're going to change it. But then there's a constitutional constraint. That's foreign affairs. That's the President's job. That's national security in the Ukraine or whatever. And so how does this work? It works without a statute because the President in his discretion provides redress for this foreign surveillance. It's a regime with binding decisions, but it's done by the President's power because that's allowed. It couldn't be done under Congress's power. They don't have the power to write that statute. So the difference here is that the law changes when the collection is in the United States or not. So the famous FISA law, FISA 702, PRISM and Upstream, that's always collection done. The collection is done within the United States, within the borders of the United States. And Congress has a lot of power over things that happen in the United States. By contrast, the foreign surveillance, the executive order surveillance, is done outside of the United States. And it's been in place for decades, and Congress has not passed statutes to interfere with the President's power here because there's an understanding this is the President's realm. And there's a Supreme Court case, now it's 7 years ago or 8 years ago, but it's still pretty recent. And Congress passed a statute on the details of foreign affairs, which is how do you recognize a country as being recognized by the country. The Supreme Court said that was unconstitutional. Congress stepped into the President's range for national security. So we have Supreme Court recent cases for each of these doctrines. And the conclusion here, the constitutionality of redress, as required by Schrems II, for Executive Order 12333, the constitutionality of redress is clear when the President sets it up. But with the current Supreme Court, there would be great doubt if Congress did it by statute. So last slide. So to date, the European courts have not found the constitution of a third state to violate requirements of EU law, including data protection law. What I've tried to show today is that there are serious US constitutional constraints on how to build redress. The framework provides redress and respects the substance of fundamental rights protections, independent impartial tribunal for every European person who wants redress and so forth. And to the extent the form of the legal institutions differs, then as Théodore would say, that's really like South Korea and the UK, then that becomes a question of essential equivalence. You get the same protection of rights, but it's done in a different form because of a different constitution. And one reason to maybe take the redress proposal is, to date, there is literally no other proposal out there that we've been able to find from anybody that meets the requirements of EU fundamental rights law, independence and the rest, and meets the US constitutional constraints. So if this goes down, if this is not essentially equivalent, I, having spent 2 years on redress, have no way to know how to make the US law comply. And it would be a decision by the EU that the US Constitution has to be changed in order to have redress. That would be a major additional step past the jurisprudence of the court. And I think now we'll get European experts to help us think about whether that's what essential equivalence requires. Thanks.
Thank you very much. And precisely, we'll get some European law control on all this and a view from Nora on all these issues and the flexibility allowed in the essential equivalence text.
Okay, well, good afternoon, everyone. I can currently see my slides, so I will stay here for the moment. I'm in quite a good position. Full disclosure, it's always a very tough act to follow, following a fantastic presentation, both by Théodore, the chair, and by Peter. But you should know I won't sing, but it's also CPDP on a Friday afternoon, so there is a puppy that's coming, but you'll have to bear with me. We've got quite a lot of EU law and ECHR legal rules to talk about first. So, as Théodore mentioned, I'm Nora Loideain. I'm joining you from the University of London at the Institute of Advanced Legal Studies. And I'll be speaking to you today about all bark and no bite. Some provocations for a Friday afternoon just before lunch for everybody on EU law, state surveillance, and the essential equivalence test. So I'm going to address rather briefly in this intervention the high level of protection established by the Court of Justice. Has this been applied consistently to other third-party states? We've just seen a detailed focus there on the US and the Schrems I and Schrems II judgments. And then the implications for this application so far by the EU as a whole, and what this means for the protection of EU fundamental rights, both within the EU and also beyond its borders. So, as previously mentioned by Théodore in the introduction, we've had an escalation in terms of the high level of protection that the Court of Justice has developed with regard to EU data retention rules. With the 1995 directive, we had a threshold under the then principal data protection directive, the predecessor to the GDPR, that the threshold was adequacy. Some people familiar with European human rights law may be familiar with this from the Article 8 ECHR case law of the European Court of Human Rights. But this has since been elevated. This has been elevated to not just adequate protection, but also effective protection. And the threshold is raised again. It's effective protection in terms of the implementation of these standards and laws. So the Court of Justice has set quite a high bar in terms of its approach and its scrutiny of third countries. And it has set it particularly with regards to the US legal order under Schrems I and Schrems II, also in Opinion 115 with regard to the draft PNR agreement with Canada, of course, that was struck down. So we have both in theory and in implementation very strict standards that are to be adopted by third countries via the essential equivalence test, which was already mentioned. Does not mean that there has to be an identical copy in that EU legal order to the requirements of EU law, but a very high threshold has indeed been set. So what does this approach entail? Well, there are many standards and many requirements, and I'll list some of the main ones, but we can always talk about them more in detail in discussion, and Anna may talk about some also afterwards. It's very much a fundamental rights-based approach. The Court of Justice has developed this case law and these data transfer rules under the adequacy agreement mechanism via the EU Charter of Fundamental Rights. And there have been particular rights that have gotten considerable engagement from the court. So under Article 7 of the Charter, which provides for the right to respect for private life, the court has held in no uncertain terms in the first round's judgment that a law permitting public authorities access on a generalized basis to the content of electronic communications, that conflicts with the very essence of the right to private life under the EU Charter. For Article 47 of the Charter concerning judicial redress, the court has also emphasized that it is inherently part of the rule of law that this is provided in an effective way so that individuals are enabled to exercise their rights. And then under Article 8 of the Charter of Fundamental Rights, which guarantees the protection of personal data under EU law, we have the complete, not just a high level, but the complete independence of data protection authorities in carrying out their supervisory roles. And the fact that they should be enabled and ensured that they can help individuals to exercise their claims and rights against any concerns they would have against concerns regarding data transfer standards. So this is when I'm going to turn over here now. The text has gotten a little bit smaller. So we know that this extends to the adequacy of third countries in terms of criminal, public security, and national security laws and measures adopted for those purposes. So this is notably broad, as mentioned earlier. Bulk data retention, as the court has recognized, constitutes a serious interference with these rights to private life and data protection. The court has also been emphatic that these measures can no longer be systematic under its data retention laws and more broadly under EU data protection law. This means they have to be subject to limitations, strict safeguards, and this is all to ensure that there is no arbitrary risk of abuse or misuse by public authorities of people's personal data. That's the underpinning rationale. And decisions giving instructions to providers, for instance, the private sector, communication service providers, telecoms, etc., this must be subject to effective review by a court or a tribunal, or an independent administrative body whose decision is binding. So the court has established these standards, and the court has also built upon these standards consistently in its case law, from Telly to and Watson in 2016 to Le Quattro Junet in 2020, and more recently again in its judgment in SpaceNet in 2022. So the court has also added to the high standards for national security surveillance laws and human rights safeguards within Europe itself. It has gone further than the standards that have been set by the European Court of Human Rights in Strasbourg. And this has become somewhat problematic for reasons that we'll get to very shortly. But the court has held in no uncertain terms that the general and indiscriminate retention of traffic and location data is only permitted for the threshold of a serious threat to national security. So this is quite a significant development because we are no longer talking about national security or just the safeguarding of national security. We're explicitly talking about a threshold within that, a higher threshold. It needs to be a serious threat to national security. So this is a standard that the European Court of Human Rights in Strasbourg, for instance, in its Big Brother Watch Grand Chamber judgment, hasn't gone anywhere near. So what is not permitted under EU data retention law and EU data protection law more broadly, well, these sorts of bulk programs are not permitted for countering serious crime, so investigations of murder or rape, for instance, preventing serious threats to public security, or indeed the safeguarding of national security. Much stricter requirements apply to that purpose. And the court is emphatic that if this were the case, this would be incompatible with the proportionality requirement and the limits of what is strictly necessary in a justified democratic society. So these are very set and very high thresholds that the Court of Justice has set. But what of these standards in terms of their consistency and other countries who are outside of the EU? So in 2021, we had legal history made with the unprecedented step by the EU to grant not one but two adequacy agreements, one under the GDPR and the other under the Law Enforcement Directive. But our most important question for the panel now is whether these adequacy decisions meet these strict legal rules that the court has set that have stemmed from the Charter and that we see being elaborated on in the judgments of Schrems I and Schrems II and other related judgments. So does the UK law meet these standards? Well, let's conclude that in a second. The Investigatory Powers Act of 2016 provides for the authorization of bulk regimes of content, of communications data, that is not subject to the ex ante or the prior authorization of an independent review body or court, or a body that is just independent of the executive. This authorization is made by the Secretary of State, a member of the executive. It is also subject to a certain level of approval, known as a double lock mechanism by a judicial commissioner, by the Investigatory Powers Commissioner's Office. But very strictly speaking, this is not independent prior authorization. And this is one of the clear minimum safeguards that have been set, not just by the Court of Justice, I should stress, but also by the European Court of Human Rights Grand Chamber judgment in Big Brother Watch. And this is very significant because in many respects, as I'm sure there are those of you who are quite familiar with this, there are many divergences between the case law of the European Court of Human Rights on bulk surveillance and also the Court of Justice. But here we have a minimum safeguard for national security programs that both courts have converged and agree upon. But that is not the law in the UK. Directions to providers or notices are issued by the Secretary of State in the UK to retain bulk communications data are not at all limited to serious threats to national security, that threshold set by the Court of Justice. They're far broader in scope. They range from the prevention of disorder as a legitimate purpose, prevention of crime, collection of tax. I don't know if you recently heard of current affairs. We now have a king in the UK. We also had a numerous amount of individuals who were unlawfully arrested. A lot of focus as a result of those arrests were on the fact that we had new public order legislation that had been introduced and that had been applied incorrectly. However, it is incredibly likely that powers under the Investigatory Powers Act would also have been implemented to collect a considerable amount of communications data about particular threats that fall under the scope of prevention of disorder, for instance, that could arise from a peaceful protest. So for issues of clarity and consistency, we are currently at a bit of a loss because we have had these standards in the UK for many years now. They were clarified under the Data Retention Investigatory Powers Act in 2014. This was a response to the Grand Chamber judgment of the Court of Justice in Telly 2 and Watson, and it was subsequently replaced by the Investigatory Powers Act in 2016. But the underpinning principle under EU data retention law, that national legislation of member states requires the retention of personal data, that it must almost meet objective criteria, establishing a connection between data to be retained and the objective pursued, the opposite of generalized bulk and indiscriminate surveillance. That is not how investigatory powers operate under UK law. So where does that leave us in terms of issues of legal uncertainty and inconsistency? All bark and no bite. We have a serious divergence in rules and standards being applied by various different institutions within the EU. This is very problematic for the rule of law. It's also very problematic for the adequate and effective protection of fundamental rights in practice. When it came to assessing the adequacy decisions for the United Kingdom a few years ago, the European Commission gave very little weight in the assessments and in their analysis, in both decisions, I should stress, to the specific rules by the Court of Justice. What it did give considerable weight to, however, in contrast, was certain standards and certain approaches by the European Court of Human Rights and Big Brother Watch. But it was very selective in what the European Commission decided to draw from in terms of that judgment. It didn't at all take issue with the fact that we still don't have prior authorization that is independent for any of these bulk powers. And that is the one safeguard where we have convergence between two of these courts in Europe that are responsible for the supranational scrutiny and are effectively the guardians of fundamental rights when it comes to bulk surveillance across Europe. So it's not as if there was no recognition of these issues. Certainly the European Parliament, the European Data Protection Supervisor, and the European Data Protection Board raised many concerns regarding the incompatibility of the UK's relevant laws with regard to the specific safeguards in these judgments, and perhaps Anna can elaborate more on that in her intervention next. But despite all of these concerns, and in reference to the statement that Théodore mentioned at the beginning of this introduction, it does raise the question about adequacy decisions being a political decision or a legal decision. Where does that leave us in terms of a summary? Well, while standards for national security measures are welcome, particularly in this brave new world of digitized environments and the Internet of Things and AI and so on, the lack of consistency and alignment by the EU institutions as a whole, or holistically, in its assessment of third countries is creating an increasing amount of legal uncertainty, and this in turn is undermining EU data transfer rules. Europe and the EU institutions, and when I say Europe, I speak broadly in terms of Europe both as the European Union and the Council of Europe, the European Court of Human Rights and the Court of Justice of the EU, for instance, they no longer have one voice when it comes to surveillance and fundamental rights standards. There's huge divergence between both courts. And this is spilling into third country adequacy assessments being undertaken by the EU as a whole. This holistic approach we can see quite evidently in the assessment by the European Commission of the adequacy decisions concerning the UK. And strangely, we see a very inconsistent approach to certain ECHR standards, but not standards coming from the case law of the Court of Justice. So this holistic approach is quite difficult to reconcile in terms of what particular safeguards are going to be imposed upon a third country in these adequacy assessments and what is not. There is so much uncertainty. So in summary, we have an EU legal framework on national security and data retention within the EU. It's already highly complex, ad hoc, and it often within itself is contradictory in terms of its patchwork of rules. And we're dealing in terms of national security and public security and even certain areas of serious crime and crime itself. We're dealing with highly sensitive areas of national sovereignty, both within the EU for member states, but also for countries outside of the EU. And it doesn't help the cause in terms of the legitimacy of EU data transfer rules in borders beyond the EU, that there's been resistance and challenge to these judgments by member states within the EU to the Court of Justice. The assessments of adequacy then by the EU of third countries and their legal orders at least need to be by all institutions done more consistently, and the same standards should be applied whether they're holistic or whether they're following those minimum safeguards of the Court of Justice in alignment. Either we're taking a holistic approach or either we're following those more prescriptive minimum safeguards. So we greatly need consistency in this space. Otherwise, this holistic approach, it's going to undermine the influence of EU law beyond EU borders when it comes to data transfers, and inevitably it is going to create gaps and undermine rights protection in practice. Thank you.
Thanks a lot, and I will give you, of course, immediately the floor to Anna for the continuation of this discussion, but just a reaction and a question for you, Nora, to answer later on, but also eventually for Anna to take into consideration. in all these opinions concerning the UK, so basically you deconstructed the adequacy decision concerning the UK, and you showed that does not meet some of the essential European guarantees. One could ask who meet these European essential guarantees. There is no independent prior authorization in France either, for instance. But let's not enter. We're waiting for the judgments concerning the French surveillance laws in September. Let's not enter into this discussion. Let's remain focused to the third countries, which is the topic here. And when one reads all these recent adequacy decisions, we see indeed this holistic approach and the idea that some strong elements in surveillance laws of other countries could compensate for some shortcomings. This is what we found in the South Korean adequacy decision, in Japan adequacy decision, in the UK adequacy decision. For instance, concerning the UK adequacy decision, there is very strong insistence on the fact that although there is no independent prior authorization, there's such oversight and control, such strong oversight and control, that probably this posterior control offer enough guarantees in this kind of holistic approach. I'm a little bit afraid that if we adopt a very prescriptive and approach focusing on this extremely important requirements set by the Court of Justice of the European Union, which EU member states do not meet. We know about data retention, what's going on. We all know all this debate. Then the effect concerning the capacity of the European Union to communicate with other parts of the world will be that not only will not be able to adopt any new adequacy decisions, but we will definitely need to undo, to invalidate not only the UK, but also South Korea, Japan, and without any doubt, even much more, New Zealand, Uruguay, Israel, Argentina, Canada, Switzerland, all the previous ones where there was absolutely no discussion about surveillance. It's only 2 or 3 pages, and it was only focused on commercial protection. If you take the system in Israel, for instance, to give an example, there have been a lot of concerns that it's far away from meeting the standards of the European essential guarantees. So how can we really accommodate this situation with the need for the European Union and the European Union companies, and I don't know, in the health sector everywhere, to communicate with the rest of the world in order to be part of this world? This is my question, and how are we going to resolve this problem? Anna, probably you could also address this issue. Thank you.
Thank you, Théodore, and good afternoon, everyone. You probably saw me shifting uncomfortably in my chair because already after your introduction, I was crossing out, the parts of my speech that you already covered, and then after your last question, I feel like I have very little to add. So thank you very much. At least, as the last speaker between you and the lunch, I will try to be brief, as a lot has been covered already. I think, that there's certainly a lot to unpack, and already in the discussions and the presentations, excellent presentations that we had earlier, it feels to me increasingly we are conflating quite different issues in our discussion. So first, to state the obvious, even though with the DPF and since Schrems II in the negotiations with the US of the new framework, the focus has understandably been predominantly on what is known as government access to data. Adequacy assessments are much more than that. So let's not forget this bigger picture. Second, I would like to insist on the point that indeed flexibility, including the flexibility necessary to take account of the fundamental, sometimes, divergences between different legal systems at constitutional level, has been built in the adequacy practice and approach in the EU from the very beginning. Now, of course, you, Théodore, in particular, have already mentioned, and Nora also, that there was a clear evolution of the understanding of the adequacy imposed by the Court of Justice. So I remember the days where the mantra of the data protection authorities, the Working Party 29 at the time, was literally that adequacy does not equal equivalence. Okay, that has been overtaken by events, or rather by the case law. Nevertheless, we still insist, and I think that it is clear from the GDPR, even though obviously the list of requirements for adequacy findings, which follows largely the case law of the Court of Justice, but also EGPB or Working Party 29 guidance is much more elaborate now than it was in the old directive. There is still a need to preserve flexibility and indeed insist on the fact that a test of equivalence, even test of essential equivalence, is not a test of identity, which is something which the GDPR, the EGPB has stressed explicitly also in our latest opinion on the draft EU-US data protection framework. But as was already mentioned, this recognition of flexibility is not reserved only to the US. We see it in the other recent adequacy decisions as well. For example, Japan, you mentioned, and there is almost always in these cases, the question about the scope of both the data protection rules that apply and of the powers of the independent authorities. Sometimes mechanisms for redress exist in relation to the public sector or private sector, but not public, and the other way around. And the EU has always found a way to work, not to work around, but to work with these differences and to make sometimes creative arrangements that would deliver what is so dear to us DPAs, but also to the court, and that is effective protection of the rights on the ground. So I hope that you will see this also in our latest opinion on the DPF, where there is a lot of focus on the effective protection, including further monitoring of the application of the future framework, assuming it will enter into force one day, and also a recognition that in fact in practice a lot can be achieved in those highly, invisible work that is being done following the adoption of adequacy decisions on the ground by data protection authorities, by the third country competent authorities in the periodic reviews. So it also, let us not underestimate the importance and the value of periodic reviews. We have also seen it, with other countries. We have also seen it with the US, where since the entry into force of the Privacy Shield, quite some progress have been made on the so-called commercial part during those reviews, and that was one of the reasons why in the latest opinion, for example, the EDPB did not have to go into great details on the commercial side of things, even though this does not mean that there are no concerns there. But obviously that was not the focus of the discussion at this point in time. I would also like to comment on the evolution of let's say the requirements over time, and about the standards that should be applied. So here I think I would have 2 or 3 comments. Well, we have already mentioned that adequacy as such used to be understood slightly differently in the past. A side note is that there was also a certain recognition that the different transfer tools in the old directive and in the GDPR, are not all capable of providing the same level of protection. That the adequacy is obviously the holy grail to be striven for, but it essentially treats the third country as part of the EU EEA data space. So it is really a very high standard, and a lot has to be done, a lot of effort needs to be put into to make sure that this framework really achieves this effective protection in practice. At the same time, there was an implicit, if not explicit, recognition that, for example, contractual tools or similar would not in practice be capable even of resolving some of the existing challenges, at least at the constitutional level, let's say, obviously redress, scope of access by public authorities. Here again, Schrems II in particular, complicated the matters a little bit by making clear that even when relying on standard clauses, the essential equivalence test need to be applied in the same way. Nevertheless, I think there is one aspect of, Nora, your presentation that I would like to comment on also, and that is the assumption I would see that, for example, all the requirements listed in the case law of the court related to data retention would automatically also apply to adequacy assessments of third countries' law. And this is obviously a very complex issue and maybe merits to be made explicit in terms of constitutional divergences between legal frameworks. So in a nutshell, national security matters are largely outside the scope of EU law as such. And also the Charter of Fundamental Rights applies to EU authorities and member states' authorities when applying EU law. At the same time, as the court made clear in the Schrems judgments, national security of third countries is not automatically excluded. And that, I think, brings indeed the question of what standards should apply to that assessment. So when the Court of Justice decides that it is empowered and competent to assess matters of national security of third countries, that it would not necessarily be empowered to assess in relation to member states, the question of the applicable standard, judicial standard, there, of course, is very pertinent. And here, the question, as you probably, well, many of you would know, has been asked quite explicitly: is the standard, the Strasbourg court case law, is the standard one specific national law, is the standard something else? And the court seems to be very insistent that none of these apply automatically. It has to be a separate standard of EU law under the Charter. And yet, what is the standard of EU law under the Charter? I would just ask the question, maybe for discussion later: should and could such a standard be construed in complete isolation from comparable decisions of the Strasbourg court? Should common traditions of the national member states' legal systems still play a role in establishing this standard? I would say that in other areas of law, we would typically see the Court of Justice build on the common national traditions of member states to arrive at the common denominator, hopefully not the lowest common denominator, but to set standards. So to me, it seems that there is not necessarily a contradiction between establishing a standard for review under EU law that would still build on relevant developments in judiciary and legal regulation in both member states under the European Convention for Human Rights and the Strasbourg Court case law, and who knows, maybe also take into account international developments such as the work that has happened in the OECD lately on the declaration on the government access to data, but also the fact that the convention, the revised Convention 108, in its Article 11, also makes an attempt to set a certain threshold that could serve to assess these type of issues and become maybe or contribute to setting a EU law standard for review that would also be, let's say, credible and more acceptable, including to the member states, than what is happening now. So I think probably I should stop now, but would be happy to answer questions.
Thank you very much. Thanks, Anna, for raising such important issues, which shows, after also the presentation of Nora, how much we navigate in a kind of zone gris, in a gray zone where we don't really know what are the standards, where they come from, when the European Convention of Human Rights standards apply. They definitely apply to direct access or for surveillance undertaking directly. But there is a tendency very often to conflate, to take, for instance, something that the court said concerning data retention in the field of criminal law and to apply it immediately to other fields. And this is something extremely dangerous. Please, if you have questions, start moving over there, because I will give immediately the floor to you. But I just wanted to give also the opportunity to Nora to respond eventually to my question and to Anna's comment, who very much joined your presentation. So.
Okay. Thanks so much, both to Anna and Théodore. I must admit, Théodore, your question was a while ago, so I may need you to repeat it, but I'm going to respond to some of Anna's points first. So I think most if not all of the points that Anna raised, I completely agree with. There is huge uncertainty as to what standards actually will be applied when a third country will be subject to an adequacy assessment. There was a certain amount of anticipation by many scholars, myself included. Lord Rexler has also written some fantastic work on this, as to how, for instance, the European Commission would assess the law enforcement directive adequacy decision differently, particularly with regard to data processing within the context of criminal justice and public security. But alas, we have not yet seen a detailed exploration as to how these two different types of adequacy decisions could be dealt with, but there's definitely scope for an evolving approach there in terms of dealing with the very different sectors of data processing within the commercial sector, for instance. As Anna mentioned, data adequacy agreements aren't just solely focused on national security matters and criminal justice, for instance. They are much broader in scope. But unfortunately, with the adequacy decisions for the UK, we really didn't receive that clarity from the European Commission that was expected by many scholars and commentators at the time. In response to the point regarding what is the relationship between the European Court of Human Rights standards in this space regarding surveillance and data retention and that of the Court of Justice of the EU, it's very important to remember that under the EU Charter, it's just before lunch, bear with me, I think it's Article 50, it explicitly states that any corresponding rights under the EU Charter with any of the same rights under the ECHR need to meet the standards of the European Court of Rights as a minimum. So this means in practice that the case law of the European Court of Human Rights provides the floor for standards, but the ceiling has not been set. The Court of Justice can, and has indeed, ratcheted up those standards. And some of those standards are very understandable and make sense, for instance, in terms of their application to new technologies. We see that in the PNR judgment, for instance. Some of the new standards of the Court of Justice are still a bit of a curiosity in terms of how they actually enhance the protection of fundamental rights, data protection and privacy in practice. So there is an absolute and very direct relationship in that the EU, not just the court, are legally required to be meeting the minimum standards of the European Court of Human Rights' case law, which makes it even more confusing to look at the adequacy assessments, for instance, for the UK, and to see that one particular proportionality safeguard that both courts agreed on, and there is not a lot that they are converging on right now, but for the one that they agree on regarding prior independent authorization of certain bulk powers. The fact that we had no convergence on that, for instance, in the adequacy decisions was quite striking.
Thanks a lot. Let's give the floor immediately to the three gentlemen in the order that...
Thank you. Is the mic on? David Erdos from the University of Cambridge. Thanks for a great discussion. So October 2015 was when Schrems I was handed down, and it was blindingly obvious at that stage that many of the decisions, like on New Zealand, but also maybe most clearly on Israel, had not been properly carried out. They had totally got the wrong scope. They'd been far too lenient on the standards. We're not going to be far off being 10 years on from that, and yet those decisions are still live. The Israeli Democracy Institute, Ami Kahane, in January 2019 said that Israeli law had no general ban on bulk collection of communications, not even a ban coupled with provisions for exceptional cases. There are no provisions in Israeli law with respect to temporal limitations on the retention of communications data by communications providers. This refers both to the communications content itself and to metadata. I mean, it really just seems extraordinarily that the EDPS and others has not addressed this glaring incompatibility and has allowed these decisions to remain unchallenged, and has allowed the European Commission to say year after year after year, it will be looked at, it will be looked at, it may be looked at. You know, this should have been done within weeks of the decision being handed down in October 2015, and yet it just simply is always kicked into the long grass, and it makes some of the discussion today look like going over, you know, very, very, very technical issues when they're glaring inadequacies in the system.
Let's take, if you want, and I know that you want to address, but let's take the two other questions also, and we will respond to all of them. Please, Ian, present yourself.
I was going to say something similar to David as my first point, but you know, indeed, and Nora, you're being very polite, but it's you know, it's not incoherency; it's the Commission not applying the law as determined by the Court of Justice.
Just present yourself, because not everybody knows you, even though you're famous.
I'm Ian Brown. Peter, I had a question for you. Obviously, there's lots of ground to cover here, and it was a great discussion. But one thing you didn't talk so much on the panel about was getting into the sort of real, you know, what does the sort of the culture, you know, the judicial, the legal, cultural differences, some of those that you described with the US, you know, it's entirely understandable. You know, I quite take your point and your argument, who knows if the Court of Justice ultimately will, about standing and US constitutional requirements and so on. But going more to the content of the rights, if you like, rather than the form. Correct me if I'm wrong, but my understanding of US surveillance practice, even post-Snowden and the changes made by the Obama administration and so on, is it would, you know, there are many aspects of it relating particularly to foreign surveillance that would come nowhere close to some of the substantive requirements that Nora was discussing from the Court of Justice. I mean, am I misunderstanding US practice on this?
I think that it is Alex over there. He would be very glad to respond to this. He responded by recent articles, by the way, but please, Alex, present yourself. Yeah.
Yes, I'm Alex Joel with the American University, and I was for 14 years the ODNI's Civil Liberties Protection Officer, so I was the prior person in that role. Great panel, great discussion. I see like two kinds of issues. One is the difference between countries, right, in the constitutional comparison. And the other one is national security versus other kinds of standards. And national security is different in many ways from other kinds of activities. And I'm particularly intrigued, Anna, by your reference to the OECD principles, which Théodore and I both worked on as consultants, and the Convention on Weight Plus work, and the European Court of Human Rights case law, all which directly address national security in different ways. But I didn't see, and I'm intrigued by this idea of an emerging norm among countries, democracies, about what is expected in the national security space. But I didn't see in the CJEU opinions an opening to bring that in. Is there something specific that you're thinking about where there's a possibility to bring those norms before the court and have them consider them?
So you have the floor.
Thank you. both David and Alex for excellent questions. David, yes, I admit, I give it to you, of course, the data, I think it can be said that the data protection authorities were not exactly very vigorous, have been so far not very vigorous enforcing transfer bans or suspensions or similar following the Schrems ruling. Sometimes talking to industry, one might have the impression that it's exactly the opposite, but fair enough. However, on adequacy decisions, I still need to insist that as EDPS in particular, but even DPA in general, we do not have powers to really force the Commission's hand here, at least not legally. And I know that the Commission services are working hard to resolve these issues, but I'm not at liberty to disclose any information right now, and I'm sure if you talk to Commission services, they would be happy to hopefully at least provide a timeline by when some announcements could be expected. And then if I could just make, before I forget, one comment about the specific UK adequacy and both the assessments by the EDPB and the Commission. I just would like to mention that context, obviously, and the fact that, you know, the master of adequacy decision remains the EU executive together with the member states. There is always a context to these decisions, right? Which goes beyond, as the entire regulation of data flows, it goes beyond purely data fundamental rights aspects. But that decision was particular in the sense that it was essentially an assessment of a member state's legal framework that was leaving the Union and that was announcing a degree of divergence in the future. But it was, it was simply a different context. So I would simply invite you to maybe wait for future reviews to see whether there might be more of a typical approach, a methodology applied by the Commission as it typically happens to assessment of third states' legal framework. That was not entirely the case because of the obvious, very particular, first ever situation of a member state leaving a certain common legal framework. And to Alex, unfortunately, fortunately, you know, as EDPS, we have been privileged to be part of some of the cases and debates before the Court of Justice in the data retention realm, but not in the Schrems rulings, for example, at least not in the second one. So I'm not sure, you know, exactly if and when there is a third challenge, whether there would be a scope or how, these ideas for the standard that should be applied could be brought in there. But I do hope that this is a discussion that we will have at some point, and that all the different efforts that are taking place at international level, but they include very many, if not all, EU member states, will also play a role in these considerations. Thank you.
Thank you very much, and I will immediately give the floor to Peter just to say how important, because you raised this for a second time, these future reviews are, and we see this very strong point in the recent EDPB opinion concerning the US adequacy draft. We see some activists who say, oh, necessity and proportionality mean nothing there. And the EDPB responds, test it. Let's test it. You need time. You need to implement. You need to see how far the US will go towards the direction of EU. And eventually there are ways to do this, because you don't have the concept of proportionality in US law, but you have the concept of reasonableness, for instance, and you could have a joint application of the two. So eventually also these reviews could be an opportunity to embark concepts such as the ones mentioned by Alex. So it's not necessarily that we have to wait for Schrems III. Probably the EDPB itself could build on any positive elements going towards this direction of convergence, even though it's not identical. It could go towards the idea of effective protection. Peter.
Very briefly, and then I apologize, but I'm going to miss my plane if I stay more than about 5 minutes. So I'm going to be brief, and then I'll leave, and you can continue or not. So I said this on Wednesday in a panel when I was sitting next to Bruno Giancarelli, which is for redress and for proportionality necessity, I see the situation is quite different. All of my remarks today were about redress and how literally I haven't seen any other thing that complies with the US Constitution that can meet European standards. So if redress goes down, we have, I think, a constitutional conflict of law. On necessity and proportionality, what I said on Wednesday is, you know, the US has done 10 things, and you might think they only needed to do 8 or 9, you might think they had to do 12 or 15. And when the court looks at it, and after all these reviews, maybe the court will say, yes, 10 wasn't enough, 11 or 12 needs to be done. If that happens, there may be room within the continuing negotiations to tweak necessity and proportionality. But that's a very different kind of outcome than saying that the essence of the right still doesn't exist for redress. Because then I don't know what to do except have Europe be saying that the US Constitution has to be amended. And I hope as allies, rule of law allies, we don't get to that.
Just in response to there's lots of great questions. I'll just respond quickly to as many as I can. Alex, with regard to your point of sources, which I think has been a really interesting theme that's emerged from the panel and in the questions as well. Bye, Peter.
Bye-bye.
Excuse me. One thing I would say is that in a lot of the policy-making materials, both within the Council of Europe and, of course, particularly with regard to data transfers within the EU, just because a particular policy document isn't explicitly cited doesn't mean it hasn't been hugely influential. So I would take that in consideration with regard to certain recommendations, for instance, of the Council of Europe, with regard to certain documents by the OECD. Explicit references isn't categorically the end metric and all metric of has this been influenced by a particular policy-making document. So I think it would be definitely worthwhile looking at future developments here, the next US-EU data adequacy framework as to particular documents that will have influenced its drafting and principles and safeguards and so on. It may be because I've spent the past few years writing a book on this. I feel particularly passionate about this subject, but the European Court of Human Rights has been providing assessments of national security systems with regard to the right to privacy for decades now. What the Court of Justice is almost attempting to do with its landmark judgment since the EU Charter became part of EU law is effectively replicate 70 years of European Court human rights jurisprudence within 7 years. And it's a very interesting experiment, but for those of you who are interested in, where a lot of these standards have come from, they have been often standards that have been ratcheted up from case law within the Strasbourg court dating back to Klaus versus Germany in 1979. But the relationship between how much the Court of Justice and the various EU institutions now are being influenced and what case law and what standards they are drawing from in making adequacy assessments has become demonstrably unclear. And both in terms of third country assessments and also just in general for things like the rule of law, protection of fundamental rights, there really does need to be greater consistency and legal certainty in this space.
Thanks a lot. I hope that you did appreciate this new angle to deal with very important questions and this collective thinking on the very concept of essential equivalence. And I would like to thank you for being present and to ask you to thank for last time our great speakers. Thank you very much, including the ones who left. Thanks.